Someone doesn't want me to speak.
Así es la vida de Estados Unidos. See?
It's an email.
Hi, good afternoon, everybody. Can I draw your attention? My name is Asad Asad. I'm an assistant professor of sociology here at Stanford. I'm stepping in for Ekber Hoyos, who unfortunately couldn't be here with us today, but he sends his kind regards. And I'm very much looking forward to this afternoon's lecture by my colleague and friend, Mayra Feddersen, titled The Evolution of Ideas in South America's Immigration Policy in the Past Century. For those joining us on the live stream, please submit any questions or comments via the YouTube chat section. And kindly note that closed captioning for the live stream video will be provided in the coming weeks. I have the special treat today of introducing Elias Aceres, who will be introducing Professor Feddersen. I taught Elias, 2 years ago now, in a required class in the sociology department, developing an independent research project. So it's good to see Elias here as a master's student with class, and I look forward to the conversation. So Elias, without further ado, come on up.
Thank you.
Thank you.
Well, you can sit right here probably. Well, thank y'all for coming out. Like, this is a very impressive person when I was researching them, and I'm really glad to present you all to them. Mayra Feddersen serves as an assistant professor at La Universidad Adolfo Ibáñez in Chile. She holds a PhD in jurisprudence and social policy, and also a legal degree from the University of Berkeley and through the School of Law at Berkeley. Her legal education was completed at Diego Portales, La Universidad de Diego Portales in 2006, and was later admitted to the bar by the Chilean Supreme Court in 2007. Currently, Mayra is one of the principal researchers at the Millennium Nucleus Migra, which is an interdisciplinary project that aims to understand the consequences of recent waves in Chile. Additionally, she also presides over the Center for Immigration Policies, a nonprofit organization dedicated to advancing immigration policy through rigorous empirical research and fostering dialogue among political stakeholders, policymakers, and civil society. In today's lecture, she'll be sharing her intellectual and methodological expertise within the field as she seeks to describe the evolution of ideas that drove South America's immigration policy in the past century via novel AI methods and on the cutting edge of how we come to research the social and political world we find ourselves in. Please join me in welcoming the brilliant Dr. Feddersen.
Thank you for that presentation. Well, in Chile we do many things, so maybe it's not as surprising, but I try to do what needs to be done. Well, so today, good afternoon, everyone. Thank you for coming to my presentation, and I want to thank Asad and the Center for Latin American Studies to invite me to present my work. What I will present today is part of a project that I've been working for the last 3 years, and that has been funded by the Chilean National Research Institute, our own NSF.
Is it off on the side?
Yeah, I don't see the red light. Let's see. Okay. So since 2010, South America has witnessed an unprecedented increase in the number of persons crossing the border. For a region historically characterized by the immigration of its nationals, this new trend has tensioned the region's migratory asylum laws and institutions. In fact, the state ad hoc responses to the Venezuelan displacement crisis raises questions regarding the strength and sustainability of this new regional framework. What exactly constitutes South America's recent institutional infrastructure? Is it genuinely an exceptional model for managing international migration? What is the real implication of this recent liberal trend. Surprisingly, there is little evidence that has problematized it. Only recently, some scholars have started to question the paradigms and the assumptions under which this regional framework was originally conceived. By scrutinizing the key ideas underlying South America policy outputs from 1900 to 2018 using a new technique labeled as augmented quantitative coding, the paper offers insight into the ideational building blocks of the South America immigration infrastructure and its implication for future developments. Despite the approval of liberal policies in the last 30 years, in the past century, South America immigration policy outputs have fluctuated between the ideas of anti-immigration and managerial developmental governance philosophies. This outcome is surprising, considering that most countries are from an eminent ascending nature. This outcome also highlights the interconnection between anti-immigration and managerial ideas, and the lesser role played by the global rights-based governance philosophy. For developing our project, we follow Bellan and Koch's definition of ideas as the set of beliefs held by institutions or adopted by institutions that influence their actions and attitudes. From this understanding, the paper draws from Pécoud's philosophies of migration governance to study the evolution of three core ideas at the center of Western immigration policies since 1945. It aims at demonstrating that anti-immigration security, managerial developmental, and rights-based philosophies are applicable to the South, but also that they can clarify the evolution of immigration policies ideas in South America. The study of how ideas evolve is important for several reasons. In the field of political science, exploring the development of ideas is crucial for understanding the nature of policy alterations and the mechanism driving those changes. In sociology, the study of ideas or frames of meaning has been pursued to show how individuals mobilize them to achieve collective goals, and how narratives and cultural symbols are instances of ideological resistance or reproduction of the status quo. Lastly, the study of the evolution of ideas is relevant for understanding how coherent ideational frameworks are and how such ideational structure affect current policy debates. Hence, looking at ideas historically becomes a relevant matter to illuminate current problems. So, today I will structure the presentation in 5 steps. We will start by briefly explaining our assumptions. As a trained social-legal scholar, it seems natural to me that legislation and general regulations absorb predominant social ideas. Nevertheless, it's an assumption that I cannot take for granted and that I need to briefly unpack to support the argument of this paper. In a second moment, I will briefly explain how we can capture meaning from text. In other words, what are the methods that social scientists have pursued, either qualitative and quantitative, to extract meaning from legal corpora. Considering the shortcomings of the current methods, I will present our technique, the augmented quantitative content analysis. The third phase of this presentation is the case study. So I will apply the methodology that we propose here to study a specific case, which is the policy outputs of 7 South American countries from 1900 to 2018. I hope that I am going to be able to show the advantages of this methodology as I review the case study and our main findings. I will close this presentation with some conclusions and a reflection for future developments. Okay, so my first assumption. We argue in this project that laws, statutes, and general regulations capture socially predominant ideas. Coinciding with Habermas, when categories, concepts, and ways of doing are incorporated into laws, they reflect what a specific group of people think are valid knowledge. Of course, I'm not the first person to think that laws absorb social predominant ideas. For example, Durkheim thought that the substance of modern law, contract, commercial, property, and criminal law, and its processes express the distinctive characteristic of modern solidarity. Marx, on the other hand, attributed a significant role to law in defining social relations, contributing to the constitutions of the way of thinking, primarily in terms of property and contract that serve as fundamental ideological support for capitalist social relations. Like Durkheim, Marx recognized the necessity of accounting for the development of law to understand the ways in which it produced specific ideas, forms of reasoning, practices at various stages in history. Recent socio-legal literature has emphasized law's constitutive power. The law in force plays a role in defining individuals' understanding of general concepts such as property, ownership, responsibility, rights. Additionally, it contributes to shaping notions of interest, identity, and community. Therefore, if laws absorb predominant ideas, we can study the text of legislations and general regulations to investigate the ideas that were codified at particular historical moments. The natural question is, how do we study meaning in legislative text and executive text? So, our proposal, the methodology that we propose for conducting content analysis on legal corpora combines a classic content analysis of text using human coding with a computational stage, where a supervised machine learning algorithm learns to code as a human and code a full corpus. Our methodological contribution is to provide a formal methodology to analyze content in large-scale legal corpora. For the content analysis with human coding, we explain the procedure following the framework described in Nuremberg, with some additional specifications required to attain the specificity of legal text. For the augmentation step, we build upon the work of Do et al., in which a human coding procedure is combined with a transfer learning algorithm. While the approach we propose resembles the one in Do et al., we make more transparent the work that social legal scholars need to undertake in order to properly code a legal corpus, and show important adaptations that are required to be made when dealing with specific kinds of texts. So what is this method? This is the quantitative content analysis with human coding. This is something that we don't innovate in this. We just adapt Nuremberg quantitative content analysis. What I do is just explain and adapt it to the analysis of legal text. So as you can see, it has a design phase and a measurement phase. The importance of this method is that all the decisions regarding the variables, the unit of data collection, the code book, are made before measurement begins, as opposed to qualitative content analysis, which is where the categories and the codes emerge inductively. In quantitative content analysis, it emerges deductively. So you have a theory, and then you apply that theory to text. It's our proposal. We incorporated the second part, the coding augmentation via a machine learning algorithm. The coding augmentation is a complementary method that aims at accelerating the coding process without compromising accuracy and precision. Usually when you do content analysis, you are doing it with a small sample of text. But our aim was to code all the laws and regulations that have been enacted by the 7 South American countries from 1900 until 2010. So for a normal person, that will require 3 or 4 years. And for the computer, it was much faster, right? And so, but we didn't want to we wanted quality without compromising the accuracy and precision of the content analysis. So this model works, it is based on a pre-trained model that was constructed to predict words. Given that the words of this pre-trained model are different from our project, what we did is we fine-tuned the model to develop our own task. For instance, a simple task is to train a model to predict the next word given a sequence of words. A more sophisticated task entails specializing the previous pre-trained model and train it to a smaller task, which is a categorization dataset aiming at predicting the specific words that we will find in the categories of our desired sample. Having the fine-tuned model is beneficial when you don't have a lot of data for your specific task, as you can leverage the knowledge of this pre-trained model, which was trained on a task where there were a lot of words. The machine learning algorithm understands the context in which a particular word appears. In that sense, it can capture different configuration of words. For example, if you have this phrase, any foreigner who conducts whose conducts compromise national security shall be expelled. Or the other phrase, like any foreigner who disturbs public order will not be allowed to enter. The fine-tuned encoder will be able to put those sentences under the anti-immigration code, even though they are grammatically different. So this is like the advantage of this technique. As a result, similar to a human coder, with a transfer learning model, the computer can understand and classify different situations under the same label. Once the computer has finished the categorization, we can test the results according to their accuracy, precision, and recall. As you can see in the slide, if the machine learning algorithm shows a low performance, there are several alternatives that you can follow in order. You can either simplify the categories, split the message into smaller units, you can increase the sample size, or you can use another pre-trained model. Okay, so assuming that, going forward with this methodology, one question that might arise is why using augmented quantitative content analysis for legal corpora, and where are the benefits that we find? Well, this was an interesting finding that despite its importance, empirical research on legislation has not been the primary focus among social legal scholars. Initial interest in law was related to non-legislative manifestations such as crime, court dockets, and judicial behavior. Most studies that have explored laws are either focused on their operation and their effects in society. These are frequently labeled as gap studies, in which they try to make visible the gaps that exist between the law on the books and the law in action. Although very insightful to explain the operation of legal institutions, these studies have been criticized because it's not clear how the law's goals are determined. Additionally, laws are vague, so the specific behavior it commands is ambiguous and not directly derivable from the laws. By conducting augmented quantitative content analysis directly into legal text, we can start addressing Philly's question, a criticism, because our analysis of legal corpora is not based on our subjective interpretation of the data, but rather it is built from theoretical driven hypotheses that we then test upon small units of text from which we derive meaning following a replicable procedure. Previous attempts to conduct content analysis on law have been employed in a small sample size. When the qualitative variant of this method has been used, scholars were unable to generalize beyond the specific case being studied. Alternatively, when quantitative techniques have been utilized, scholars often have relied on binary variables that overlook the nuances and complexities of legal texts. We believe that with the augmented quantitative content analysis, we can leverage the advantage of quantitative content analysis by extending its application to an entire population and incorporating variables that can capture both breadth and depth. We will use the South American case to study and to implement this methodology. Let's see, and this is the interesting part perhaps, or more interesting part, how it worked. Okay, so in this section of the presentation, I want to show you how we applied our methodology to study, as I was saying, the evolution of three core ideas in immigration policy output in South America. South America is an interesting case study because compared to the West, in the last 30 years, policymakers in Argentina, Bolivia, Brazil, Chile, Colombia, Ecuador, Paraguay, Peru, Uruguay, and Venezuela have enacted legislation moving towards universality. This development is both innovative and exceptional, yet it has been insufficiently explored. In this case, we study South American governance ideas to understand, to explore how coherent was this novel and exceptional regional framework, and how it differed from Western models of immigration governance. We review the key legislations and general regulations of Argentina, Bolivia, Chile, Colombia, Ecuador, Peru, and Uruguay from 1900 to 2018. We selected these countries and their respective laws because they capture various migratory dynamics. Simultaneously, we aim to test the three most prevalent ideas about immigration governance in the West using the same legal corpus that previous scholars have examined. Our goal was to unpack the scope and characteristic of this regional framework. So the first step in any quantitative content analysis, the human part of the content analysis, is to select the variables. To that effect, we use a refinement of Pécoud's philosophies of migration governance. Pécoud has a categorization that aligns with immigration governance patterns of major receiving countries since 1945. While it has been not empirically tested in the South, it coincides with Marmora, which is a South American sociologist who have reflected about South American immigration governance. And we build from Pécoud's and Marmora's account to find the main ideas that we could observe in South American immigration policy governance. Furthermore, we don't take Pécoud's typology at face value. We use, as I was saying, a refined version of his 5 philosophies into 3 core ideas that we believe are applicable to South America, because they encompass the realities of countries facing forced expulsion, population exchanges, and refugee flows, which are more likely to be found in South America and in the South. The first variable is the anti-immigration security. This idea aims to achieve the immobility of immigrants either by strengthening controls at the borders and deporting unwanted immigrants, or through the creation of precarious subjects prone to labor exploitation. A wealth of literature has demonstrated how countries receiving immigrants have undergone a security shift. Even in South America, this security shift is rooted in the absolute sovereignty of states, which entails the exclusive right to control the admission and treatment of non-nationals, premised on the belief that immigration is a security threat and that the control of immigration is of strategic importance. The second variable is the managerial developmental. This idea tries to bridge the security and human rights concerns on the belief that it is possible to control immigration flows to obtain optimal results. This variable emphasizes state capacity to use immigration to its advantages, establishing regulations and prescriptions that favor the orderly and regular circulation of migrants and ensuring that they can contribute to the receiving society. It is also an idea that seeks to protect the migrant and its family, aiming to ensure a safety immigration journey and their secure and easy insertion in the receiving society. For sending countries, the managerial developmental idea takes advantage of immigration to reach growth-related goals. These countries support their economies on labor export, remittances, and acquiring skills through their diasporas. And lastly, the third variable is the rights-based governance philosophy. This idea emphasizes immigrants' human rights and the liberal principles that justify individual entitlement against the state, based solely on the fact of being a human being, regardless of legal status. Empirically, this philosophy has received significant attention as it operates in contrast to the anti-immigration security paradigm. Nevertheless, it has never been empirically systematically tested. The last variable is the other. This is a common variable in quantitative content studies, where the coder categorizes any message that cannot be assigned to any of the previous variables. This category ensures that there is no manipulation of the data. So the second step in quantitative content analysis is to decide on the unit, the message that we will study. Here I put some examples to show you that instead of looking at the entire corpus of each law, what we did is that we chose the article paragraph unit, what you call it in Spanish, artículo, or section in English. Because legal documents, they serve multiple purposes at the same time. There are previous studies that have looked at the entire corpus of a law as a single unit of observation. But we believe that a better measurement is to divide all the legal text in specific articles or sections to to find the specific message that is captured in each of the articles, even though a law might have contradictory messages. In political science, there is abundant literature that shows that legislation, general regulations, and treaties emerge from negotiations among different interest groups, resulting in text shaped by general compromises. Consequently, many provisions are intentionally vague, aiming to reconcile different perspectives. Analyzing the article paragraph unit allows for a realistic and nuanced understanding of this complexity. Well, the third phase of the quantitative content analysis is defining the variables. So, applying the definitions of the variables that I already gave you, we created this code book where we wanted to select a specific amount of questions, a set of questions that could help the coder identify when a message fell in one category or the other. The anti-immigration security message was coded accordingly when the coder affirmed any of the following 8 questions are true. The same as with the managerial developmental code book, the coder had to affirm any of these 7 questions to be true. And the last one was the right-based code book, which, as you can see, having less questions doesn't mean necessarily that it's a less nuanced code book, but it was easy to identify sections that related to rights that it was for the anti-immigration or the managerial. So it required more specificity in terms of what we were trying to achieve. So lastly, the rights. The fourth phase is deciding what our sample population is going to be, finding it and preparing it for the analysis. The table here presents all the different legal sources that we found that regulated the entry, stay, and removal of migrants. We included refugee laws because we understood that immigration involved voluntary but also forced movement. Our sampling logic entailed selecting every law, statute, or general regulation that was targeting immigrants living in the territory, the entire class of immigrants, or a specific subclass of immigrants. We found in some countries, for example, there were special provisions against Chinese, for example. We found laws through the official websites, and we checked it through secondary evidence, history books that referred to particular laws, and then we found them on this official website. And in one case, in the case of Ecuador, we had to pay for a commercial Lexis to get at the law. But in general, we were very lucky. We were able to find most of the laws that were cited in secondary evidence in articles. And then also in some cases, we had to go day by day exploring the official newspaper where these laws are published to find all the laws. And as you can see, we had a total of 635 legal texts of different nature. This is a classification. All these statutes or the law is just one category of a general act, but there are also, because in some cases these countries were under military regimes, they had emergency decrees, or sometimes executive decrees are. So the main idea is that the application of all these statutes is for the general population, not for specific. So what we left out were administrative decision, extradition treaties, and the regulation of national abroad. Why? Because we were looking to see how immigrants were regulated within the country, not outside of the country. As you can see, and then we paid attention and we categorized the 9,000 the amount of articles. We didn't look at the law in total, but it's just to give you a sense of this data. So next, the human coding. So what we did is that we draw a sample of a stratified sample, a random sample of all the articles, and 2 coders independently had to code the article using the previous variables that and the code book that I showed you. In total, as I was saying, the human coders manually coded 1,610 articles. And what did we find? A first interesting finding is that based on the human coding, we were able to identify the number of articles categorized according to each of the variables. So this information allows us to have an overall view of the prominence of each immigration philosophy over time. First, in South America, states' primary concern has been the management of immigration flows. This observation aligns with historical trends as the countries have utilized immigration rules for nation building purposes and also for industrial and economic development. The prevalence of the managerial philosophy challenges conventional literature, which typically traces its origin to the 1990s and links it to the operation of the International Organization of Migration. In the case of South America, we find it to exist even before the International Organization for Migration even was built or created. Second, in contrast to the Western context, security concerns have not taken the forefront in South America. This can be attributed to the fact that, with the exception of Argentina and a brief period in Uruguay, our sample countries are primarily emigration countries. Therefore, restricting the movement of immigrants within the territory is not the primary goal among South American states. So that's probably an hypothesis why the anti-immigration is not the most prevalent idea. Lastly, the notion that immigrants possess rights, which in turn may impinge upon state sovereignty, is a less important category. Even though in the last 30 years, all the literature is saying that there's been a liberal turn, we can see on time that rights have not played a significant role in the regulation of migration in South America. But another interesting finding that we can do thanks to the augmented quantitative coding is the interaction between the different ideas. So here you can see that we have all the countries, and we've put different colors. So black is anti-immigration, and you can see how the idea of anti-immigration has evolved over time, how the idea of managerial has evolved, and how rights have evolved between 1900 to 2018. So you can see the relationships between the different ideas. A first discovery, which matches with the prevalence classification that I showed you before, is that the rights-based governance is the less relevant of the three philosophies, confirming that immigration continues to be dominated by the absolute sovereignty of states, where individual entitlement are recent concessions. So if you want to see this liberal turn, you have just to look at the last period, and we see that even in the last period, security concerns or the managerial are still more important than the rights-based governance philosophy. Second, that the anti-immigrant governance philosophy has been a relevant paradigm in the history of these countries. However, contrary to the thesis that restrictive migratory regimes heightening during the region's dictatorship, we found that the most stringent phase did not took in this area where we had the dictatorships in South America, but it was rather between the First World War and the Second World War, before the beginning of the Cold War. So that's interesting. And you can see, if you look at the articles, you can see that there was a concern among nationals that the revolutionary ideas were coming to the revolutionary idea represented by foreigners that were arriving to their countries, and that those immigrants were dangerous for the building of their new societies. Third, in the Global South, the managerial developmental governance philosophy, as predicted by Adamson and Tosorupa, is highly significant for the region. In fact, it is a philosophy that has been at the core of nation-building projects, the population of these vast lands, but also the industrial development of many of these poor countries, And in some moments in time, it has even been more influential than the anti-immigration governance. Lastly, we see an interesting interaction between the anti-immigration here and the managerial. Look at the relationship between the black and the brown. There seems to be a reactive relationship between both ideas. In other words, the prominence of one philosophy over time is directly connected with the weakness of the opposite idea. States reacting and distancing themselves from their past, enacting opposing legislation, deciding to uphold what they see as the opposite idea, which it turns out to be is not the rights-based governance philosophy, but is the managerial one. So it's just theoretically the managerial philosophy is supposed to be in a middle ground between the anti-immigration and the rights-based. But in this case, it seems that the opposition is between the anti-immigration and the managerial. So the rights is not in the picture. So that I think is interesting. I don't have an explanation. And lastly, we created an openness index. This index is a summarized representation of the interaction among our three variables. We wanted to see what was the position of each country in regard to the regulation of immigration. Since we have categorized each article with a specific philosophy, we can assign a degree of openness to each article section. We assign a score of 1 when the section was categorized as right, 5 when it was categorized as managerial, and 0 when it was categorized as anti-immigration. Then we took the average across all the articles within a given period, and we obtained an indication of the degree of openness. And what did we find? Regardless of the country migratory dynamics, immigration policy output in the seventh country we examine are neither too restrictive nor too open. In the aggregate, all countries except for Bolivia, who slightly regressed in the 80s, they appear to be moving toward more liberal stance, but it's much more subtle than what the liberal term literature identified. In Chile and Argentina, it's a rupture from the past, probably because of military regimes, and they wanted to show, the new democratic regimes wanted to show a difference from their past. But in Ecuador, Colombia, Peru, and Uruguay, the difference is not radical, but only a small change. Looking at the countries individually, it is interesting to notice that Argentina, Uruguay, and Peru were the most restrictive ones. This can be explained by the fact that before the 40s, these countries were most immigrant destination, or at least compared to the others. The existence of military regimes does not explain more restriction. This finding matches Catarina Nater's argument that military regimes can use migration in their favor, which does not necessarily implies restricting it completely. So to conclude, because I'm over my time, thanks to the augmented quantitative content analysis, the analysis that we are able to do is closer to a census, because it's possible to cover the entire population and not just a representative sample. Contrary to other migration indexes, the augmented quantitative content analysis variable measures depth and breadth. Depth because immigration governance philosophies are substantive constructs, and breadth because we can do it over a very long period of time and compare different countries. The exceptional aspect of South America lies, we believe, not in its liberal turn, but in its moderate outlook. And our future steps involve identifying the factors that explain the additional changes that we found to try to unpack some of the dynamics and surprising findings we presented today. Thank you very much.
We can open it up to any questions. Alberto?
Okay. Fantastic work. It's incredible. I want to ask you a couple of things. One is about the corpora, the corpus, the corpora. Why did you lump together the decrees and both the executive decrees and the emergency decrees with the law? Because you yourself said that the law comes from these compromises that happen in legislative debates, as you as you settle on some piece of legislation, and it might be quite different from whatever discourse, Peronistas or whatever are saying, or the different parties would have very different positions on this. So I really am struck because in some ways you would expect that the executive decrees would have much more of an imprint of the executive, whoever it happens to be, authoritarian or democratic. And the second thing is really about the Dan Abramitsky's work on using this kind of thing for speeches in the case of the US, where he and his collaborators, the whole team, they have been able to look into things like dehumanizing language as it is reflected in the words that are being used. So I was wondering about whether you can, kind of the rights-based approach strikes me as too legalistic, and in these things you can actually, now the people do things which are more about the sentiments that are actually involved, and if people are not familiar with Abramitsky's work, is they can actually measure when immigrants are kind of equated with animal language phrases rather than human language phrases. They actually can do this kind of things today. So I'm sorry, it's just exciting work, and maybe I'm asking too much.
No, thank you. I take a few, or I respond directly. Okay. Well, I think I'm trained as I was first a lawyer, and then, if you can call a social legal scholar. So the reason why I wanted to look at the laws that in terms of that were the most general ones that could be applied to a bigger population. So I was not focused so much on what the specificities of each, the content of each law. I just wanted to see if I get into a country, what will be the rules that everyone has to follow. And so if you're looking at the rules, because I assume that those, even though I am not looking at the implementation of those rules, so only I'm looking at how they are formulated. But when they are approved, after they go through Congress, and once they are approved, and they become the law of the land. And the law of the land is not just composed of laws, it also includes constitutions, which is a little bit higher in terms of in law there is a ranking. The higher law is the constitution, then is the ordinary statute, and then you have executive decrees. But in immigration, usually governments, they don't go through Congress, they govern through executive decrees. So I had to incorporate also the executive decrees, otherwise I would not get into what I thought were the socially predominant ideas at the time. And in South America, we had periods where we only had military regimes. And military regimes, instead of going through Congress, they legislate through emergency decrees. But some of those emergency decrees, they stayed in force even though the military regimes ended. For example, in Chile, the immigration law in Chile was enacted during the military regime in the 75, but it continued to operate until 2021 when it was overhauled by a new legislation. So it's true that military regimes could have, or the hypothesis will probably, or I was expecting that those emergency decree will favor the anti-immigration rhetoric more, but I did not find that. Usually maybe because immigration was not the main concern, at least for many immigration countries, so they just copy what they found in previous years. So it was not like a completely rupture from the past. It was just copying what they already had. For example, in the Chilean case, the emergency decree that regulated immigration was very similar from one that was enacted in 1953, which was enacted by. So in this case, I don't know if I completely answered to your question, but I wanted to see the different levels, and the reason why I separate, because I had this idea that I could compare if the ideas were different depending on the type of legal text that you were looking. So whether laws are different to executive decrees or to or treaties, because in South America many rules came from conventions between two countries, like for example Uruguay and Germany, Uruguay, and there was no actual law, but there was some agreement between the different countries. So I also incorporate that because I also consider that to be a rule that govern at least different groups of immigrants within the country. I did not look at speeches because, and these lawyers are very strategic in the words they use in particular legislations, so it's not as emotional as the debate that you will find before the law is approved. So one category that I had to erase because it was I had too little observation was race. I looked into then race. I put it into the anti-immigration because the result was to restrict the mobility of certain immigrants that pertain to particular races. But what I found is that the laws were racially neutral. It didn't mean that they were not applied in a way that impacted some groups over the others, but at least they tried to be racially neutral, and that fits with David Fitzgerald's book that shows that South America enacted less racially or eliminated racial distinction before the United States and Canada. I did found some, for example, in Argentina there was in the constitution a particular section that say only white immigration is allowed in this country with those terms, and in some cases there was a specific provisions against Chinese. For example, Peru prohibit the entrance of Chinese nationals. But I could only find 10 observations of those, and for the machine learning algorithm, it was too small of a sample for it to be able to categorize those examples in a precise and way. So that's why I did not focus on sentiments. But what I would like to do is then, after I publish my findings, I would like to put this data set into public, make it available to the public. So I believe that there could be many other uses that you could put into the data. So one thing would be interesting to analyze sentiments. And I would say with this technology, with machine learning, is a little bit easier because it doesn't rely that much on the word specific. So you can have different configurations, as it's not like because there is no comma then, like you have to write all the possible. No, in here you have some leeway that allows you to do more interesting work. Yes, Matt.
Yeah. So thanks, Mayra. This is fantastic. Really interesting, especially methodologically. I was intrigued. Two quick questions for you. Theoretically, I was curious whether you take these ideas as you phrase it in a Durkheimian sense, actually reflective of predominant social ideas, or more these are sort of elite ideas about immigration, and predominant actually, it's not really a statement necessarily on, prevailing social sentiments in these countries. And then a second question for you is methodologically. So, as you know, I love interpretive qualitative analysis, and I'm always intrigued by my colleagues at Stanford and in this broader Silicon Valley area with AI and modeling. And I'm curious for you in this in particular, if you could tell us a little bit more about how each article in the statutes, right, is sort of coded. So in particular, I'm curious, so if there's a statute, for example, where maybe 10 of the articles in the statute are anti-immigrant, 2 are rights-based, is that you're just counting that number, and so like it's 10 versus 2, and that's what we're seeing in these tables? Are you making any sort of analysis or interpretation of actually the way the rights articles are written are like very intensely sort of like expansive and are actually quite like dominant, right, in this piece of legislation in total compared to the anti-immigration one? So actually, even though there are only 2 quantitatively compared to 10, really this piece of legislation is really a rights-based piece of legislation, right? And so, I'm just kind of wondering, right, if we could disentangle sort of just like counts versus prevalence or predominance or a change or meaning of legislation and how it's actually going to be enforced on the ground.
Yeah, very. Let me finish writing. Well, I think you are right. These are probably elite ideas because they are the laws are the results of what policymakers have finally approved and made and published as law. So I'm not looking at least I'm not looking at what people understood those laws to be. And the second level would be the elite will be Congress, and a second level of elite will be the executives that complement those laws by writing those executive decrees. But still, like, I don't know what is happening necessarily on the ground. Like, I cannot. That will entail doing like very in-depth case study to understand what a specific public officials think about what's the meaning of the particular terms, but that I think should be another project. Like, I could look at administrative decisions, but I don't know if I will find enough meat, because sometimes those decisions are very shallow in terms of there are no arguments or rationalization why they are applying the way they are just doing it. I think interviews could help you like identify the rationale for making those decisions. But that for 7 countries, I don't think I will be able to do that. So the method. So what we did is that I look at, like, I had one, for example, one law that had like 200 articles, and then we had a program where it took it was an important work that we did, because some of the laws were like pictures, so we had to transcribe them by hand to make it readable to a computer. So we had to transfer every law that we had into like an Excel file, and then the computer just selected the ones that said article, and from the beginning to the end of the new article, and so we categorized each one individually. So at the end, we were not looking at laws in specific, but just the articles. And one thing that I wanted to do also is that sometimes laws, they have like in an expression of motives at the beginning. Like, they explain why they're enacting this law, what are the goals. And so what I did is that I articulized those paragraphs as well, because I didn't want to leave them out of the analysis. Because many of the rich information then for public officials to interpret comes from the introductory part of laws. So I divided those. I create new articles just for the computer to, like, I didn't want, the only things that I left out, the other part, were like procedural instruction, like publish this in this newspaper, send it to this ministry because it didn't offer any insightful information. And once I had all those articles coded, then I think we just counted. I think it was very basic, but it's interesting. How it's going to be enforced? Yes, I have no idea. I would say probably, and the literature shows that there is a gap between what the law says and what happens on the ground. But this, as a first step, I think it was helpful to, because most of indexes that are based on the analysis of policy outputs, they are looking at the laws, at what we call the URE law, like the law how it is written, the formulation of the law, not the implementation. So I was following that, those authors trying to approach, maybe like as a proxy. I hope it's not a perfect proxy, but it was good enough to at least understand, okay, if we can look at the immigration governance over the years, how it has changed, what are the ideas that were more important at certain particular time, why they were more important at particular time. So this piece is more descriptive. I would say now my big work is like trying to explain why I find these changes. And so I've been like drafting with my assistants. We've been drafting historical accounts of each country in periods of 20 years. So now we can see, for example, variables that we know matter, like for example, economic, like what are the economical situation at a particular time? Did that play a role in like explaining, for example, passing from managerial to anti-immigration because there was an economic crisis, or because there was a coup, or because there were like social movements? And so that's like the second part that I need to do. And I'm not looking necessarily at change, because my baseline is, I don't have a baseline from which to compare. I would say it's, maybe it's sad because I'm just looking at, I wish I could be doing more things, but I'm just looking at how many of these codes I find in particular time periods, because I have I have the date of the publishing date, and so I can trace it and I can compare the different countries. So yeah, as a starting point, I think this is it. But I'm open to make more in-depth analysis. Yes.
Thank you, Mayra. This was really impressive. And my question comes from someone that has zero knowledge of quantitative analysis. But I just have this reaction that I'm going to try and translate into a question, because I find the information you've given us very interesting to think along lines of migration in Latin America that also entail internal migration or domestic migration, and also the fact that the way in which you describe the problem of situating racially marking immigrants in which of your set of your code books would have been sovereign, like the security or the managerial, because there are populations like the Mapuches that are in between the two nation states, and how would those two be marked, and with regards to which of those two code books. And I wonder if you've encountered similar, something along those lines, or if not, if you could speculate how that would look like.
Yeah, I only, like, the sample was only a status general decrees that referred to immigrants in particular, international immigrants. But there is definitely a story about the indigenous group that were moved away because the immigrants came, right? In several countries, immigrants arrive, at least in the 20th century, immigrants arrive to the lands that were indigenous lands, and they receive like benefits from the government to work the land, and so there is a story there, but since I'm only looking at the laws that provide and give those tax benefits, I am not looking at what are the consequences or if there are indigenous legislation that come into conflict with the immigrant legislation. In terms of internal migration, I think the Colombian case is the most interesting case in that regard, because of I think Colombia is, even though it's a country that has not, I would say now has a bigger immigrant population because of the Venezuelan displacement crisis, but before it had like a very small amount of immigrants. But even though Colombians are very good, they are, I will say, they like the law, and so they are very fertile in creating a legal text. So even though it was not like a country that you will expect to find much regulation, there were plenty. And it was, as you can see here, let me show, because I think this, for me, the most interesting graph is this one here. So Colombia is it's mostly, and Colombia for some reason maybe it wanted to attract more immigrants, like qualified immigrants, I would say, because it believed that it could take advantage of the skills and so anti-immigration, they were not concerned, and I would guess because the numbers were very low, right? But I know, because in all the history there is more violence and a lot of displacement, and but those are not categorized as immigrants, so they are left out of the sample. But of course, historically, I think we have to explain that part. But I was surprised by the way the statutes were formulated in terms of really trying to so the managerial really capture was the Colombian state trying to in Chile it was the same, like we want the European immigrants because they are going to teach the locals, the indigenous population, how to work, effort, and in Colombia it was similar in some way. They were not as racist, I would say, as the Chileans, but at least they were trying to like give them a lot of benefits to like import their goods and to work in areas where it was difficult to work. And well, Argentina, I would say, is the only country where anti-immigration was really high because of the numbers of immigrants that arrived in Argentina at the beginning of the 20th century. So they had specific, like they had one of the. It's not a coincidence that I put you this section that said in Peru, crazy, idiotic foreigners or professional beggars or vagrants or sick people without resources and incapable of earning a living or who suffer from a disease that is dangerous to public health shall not be admitted to the territory. And this is from 1920. So it doesn't look too different from what we will find now, but it's interesting. And on those years, I would say it's the period where you find more restrictions, and the racial ones are because of, as I was saying to Matt, we only have a few observations. At the end, I put them together with the anti-immigration because they involve restricting the movement of people, expelling immigrants that belong to those racial groups. So yes.
Mayra, I have to say thank you. I'm going to wrap us up. So
Yes.
Let's give Mayra Feddersen a round of applause. For those of you on the live stream, thank you for joining us. And for those of you who are here in person, thanks for joining us this week. Please join us again in 2 weeks on Friday, March 1st. Where we will have a talk on how domestic litigation in foreign and international courts contributes to accountability in Latin America by Senior Staff Attorney Claret Vargas. And in the meantime, stick around, have some cafe, some donuts, and for those of you in the online world, see you next time. Thanks, everybody.